Good afternoon, guys. My name is Alina Shaltsova. I'm an immigration attorney from New York. And today we're going to have a live session. We have them regularly, usually on Tuesday nights. We're going to discuss immigration courts and recent USCIS news. So thank you very much for joining. If you are new here, welcome. I'm practicing in New York for almost 15 years, United States immigration law. And you can find a lot of free information on various aspects of immigration law on my website, www.shaltsova.com, on Facebook page that is extremely popular, and we currently have more than 500,000 followers, and of course on this YouTube channel. I also sometimes do some TikTok videos on various topics, so you can find me on various different platforms. And most importantly, when we have such live presentations, I also answer some of you guys' questions in the end. So thank you for joining. I see people joining. Hi, Ali. Hi, Tia. Hi, Amir. Let me know where you're watching from. Hi, Chowdhury. I'm good, thank you. Hi, Amar. And we are going to start. This particular presentation I wanted to dedicate to immigration courts. Many of you are waiting for immigration court hearings. Some of you want to get into immigration court. Perhaps you have a relief that you are trying to get, and it's only possible if you are in immigration court. For example, you're looking to try to go for cancellation or removal. This is something some people refer to it as 10-year green card. This relief is available only if you are in immigration court, not if you are just trying to file it affirmatively with USCIS. And some of you would like to have your asylum case to be heard again after denial at the interview, even though they don't call it a denial, they call it a referral, right? So it's important for you to have your day in court. And some of you do not want to be in immigration court. You're afraid to be deported, to have this order of removal against you. And I would like to share with you the latest practice, what's actually happening in immigration court, so you will have maybe some better understanding of what's going on right now. Well, first of all, you need to know that immigration court individual hearings after long delays related to COVID now are full force. If you're scheduled for an individual hearing, you will go forward, your case will go forward, unless there is some sort of an emergency and there is a short rescheduling, usually it's for 30 days, no more, your case will go forward. It means you have to be prepared if you want to go forward. But if you don't want to go forward, now still is a good time to ask for that prosecutorial discretion, right? Dismissal of your case or administrative closure, depending on what's best for you. Because remember, dismissal means you're out of the court completely. Pending applications will be closed, such an application for asylum, for example, and your work permit will be lost as well. Administrative closure is different. Administrative closure means that you're still in immigration court. You can renew your work permit if you have certain pending applications, but you're just not going to be on active court calendar. If you recall, when Trump administration came to power, they started reopening some of the administratively closed cases, trying to deport people physically. But to deport somebody physically, you do need to have that order of removal that is final by the immigration judge. So when you go for an administrative closure, unless you have some sort of a plan in the future, for example, you have an I-130 pending. I-130 is a petition by your U.S. citizen or green card holder relative. Usually it's going to be a U.S. citizen, and you need to wait for it to be considered or to be current. Then administrative closure will make sense for you. Means that you ask the court to not have your individual hearing. You do not have to prepare for that asylum hearing if the court agrees, but you do not want to be completely be out of court because maybe you believe that it's going to be faster for you to adjust once your I-130 is granted before the courts, something like that, okay? But for most people, of course, dismissal probably will be preferred way to handle the situation, unless you want to go for trial. Because there are people who want to go for trial. I have a lot of clients who tell me, no, I would like to have my day in court. I believe I have a strong asylum case. I would like to try my case. I cannot go back home, and that's totally fine. Most hearings, actually, I would say 99% of them currently are going to be online. You can connect online from your home. You don't need to travel to court. In fact, court, at least in New York, prefers that you do that instead of traveling to court. I recently had one client who insisted that he'd like to come to court. He did come to court, and the court, of course, accommodated the client, but the court was not happy about that, okay? So you would want to connect from your home, usually, perhaps from your attorney's office if attorney is practicing in-person meetings and so on and so forth. But some people would like to be in court, but they're not. They're not. So what's happening? Well, what's happening is that, unfortunately, we have huge delays in certain areas of the United States immigration system. And one affected area is filing of the notices to appear with court, that for some mysterious reason is not done. And some people like that. Again, not everybody wants to be in court, and some people hate it. They want to be in court. They want to have the date in court and file for something. And you may find yourself in this situation usually if you came to the United States through the border at point of entry. You requested asylum, or you were paroled in, and you were issued notice to appear, but it's not filed in court. So when you punch in your A number in that EOIR online system, it's going to give you a message that no such case is found. That's one situation. Another situation would be if you had your asylum interview, for example, and you were referred to court, and you even received a document showing that you have a date in court. But when you came to court, the court stated, well, sorry, the case has never been filed with us and you're not on the calendar today. Happens. All right, so usually ICE would be responsible for filing of these notices to appear with immigration court. If you are in this situation, you really would like to have a hearing, perhaps you have a situation when you need to file some application for relief, right? Because the court is not going to accept application for relief usually unless your case is actively scheduled. In that situation, you would have to call or contact court administrator and ask them to accept the paperwork. Some court administrators actually gave these guidelines to attorneys. Then you have to work with your lawyer to try to have your case scheduled actively put on the calendar. So you can file your applications for relief. You know that you're going to be heard. You do not want to have your case dismissed. Interestingly, currently DHS, a branch of DHS, OPLA, Office of Principal Legal Advisor, files motions to dismiss cases where NTAs were not filed with court. According to the news I received, 1 out of 6 cases is being dismissed for that reason. It's crazy. And I said, some people are happy about this and some people not, because they do want to have their day in court. So these are the challenges that we're facing in courts right now. Another interesting fact that you need to know, that some cases that were newly opened in court are subject to electronic filings. Very important to know that. And some cases are subject to paper filings, meaning that you have to file your paperwork physically, right? And some electronic filings, that means that your lawyer usually would upload the paperwork online. you have to know that when you are filing papers physically with the court, you must give a copy of your filing to the prosecutor. Otherwise, it's not going to be properly filed. If you're representing yourself, if you don't have a lawyer, you don't have the money for an attorney, or something happened, you were left without an attorney, you need to know that. And in this situation, you should look at something called Immigration Court Practice Manual and learn how to properly submit paperwork to court. Very, very important. Now, I'm going to tell you one more interesting thing about the immigration courts. A recent decision came out, and this decision doesn't concern everyone, but it may be useful to some of you. So this is a decision about a person who came to the United States on a visa waiver program. The person was not from a visa waiver country, but the person used passport, fraudulent passport, and presented himself as if he is from a visa waiver country, meaning that he didn't have to have a visa to enter the United States. He was allowed to come into the United States, but was placed in removal proceedings. You need to know that if you are in a situation when you enter the United States on a fraudulent passport, it's extremely important to know how exactly you entered. This is a very good example of what's happening. Even though the person had a false entry, the person was treated for legal purposes as if he was from a visa waiver country, and his rights to see immigration judge and apply for certain reliefs were extremely limited because of that. In other words, in the United States, there is a practice that if you pretend to be someone, you're going to be treated as such, even though you're not. It's a very interesting phenomenon. For example, if you enter in the United States using a US citizen passport, you are not considered to be inspected and admitted for subsequent adjustment of status purposes. And this same logic applies now, for example, to people who enter the United States on a visa waiver. This decision came recently from the Third Circuit, New Jersey, and the person basically was denied adjustment of status. They could not get the green card based on marriage because they entered the United States on a visa waiver. The court stated that you're not entitled to anything except for asylum in this situation. You only can request asylum. And the person withdrew the asylum application because they thought that they can file for adjustment of status. So they were left without relief, right? Mistake, difficult situation, but when you have, certain facts in your case, you have to work with an experienced attorney to be ready for such an outcome, all right? That's something you need to know. Last thing I wanted to tell you, which is kind of interesting and at the same time sad. USCIS, starting probably from the pandemic, has this practice now of issuing requests for more evidence or sending you a message that request for more evidence was sent, but you never receive it. And no matter how hard you try to get that copy of that request for more evidence, you're not receiving it. It's interesting because I just encountered such a situation with one of my clients, and the situation happened with Vermont Service Center. It has to be applied for a perfect TikTok video, I have to tell you. Because what happened in that situation, that client receives a message saying that request for more evidence was sent to you. And usually if you are in Vermont Service Center, meaning that you are some sort of humanitarian relief applicant, it's your lawyer who's going to receive such a request. So my office never received the request. I informed the client about it. We placed an electronic inquiry using USCIS tools, saying we never received the request for more evidence that you are referencing in your message. We received a paper reply back saying that it's improper way. You asked us for this, you contacted us in an improper way. You should mail your request. All of a sudden, okay, we mailed the request. Several months later, we receive another answer saying, that's improper way you contacted us. You should not be mailing us the request, and I'm not lying right now. You should contact us using the referral tools, which we did at the beginning and received a different reply. So for 6 months, we're getting run around and my client gets extremely frustrated. I suspect strongly that there is no RFE at all at this point, but I do not know. It seems that we're not the only ones in this situation. I just received an update from AILA, American Immigration Lawyers Association, where they actually met with USCIS ombudsman addressing this issue of missing requests for more evidence that never were delivered, said to be delivered, but you never received it. So if you are experiencing something like this, it's not your lawyer's fault. I don't even know whose fault is this at this point, but know that you're not alone. You know, we're probably going to be refiling the whole case just to see what's going to happen, because in our particular situation, it's not going to hurt us. And you also can file for FOIA, Freedom of Information Act request, and request a copy of your file if you have time. But in certain situations, of course, there is a concern that you may be denied, right? So that's how it works. If you don't reply to requests for more evidence, your case will be denied. So it's challenging currently. It's challenging. You do have to have a lot of stamina to deal with certain issues that arise. But this is something I wanted to share with you. So perhaps you'll find this useful, this information, so you won't be too afraid, too upset if you encounter something like that. And now let me see your guys' questions. Hi guys, hi Tia, hi Street, hi Anja. Wow, you're in Dubai. Hi Mohammed. Hi Beverly. Very nice to see you, watching from California. That's nice. Have a little bit of time difference there. Hi Ali. Ali, please update us about Essential Workers Immigration Plan. Lee, there is nothing more than I would love to talk about, but there is nothing. There is literally nothing. If you open the news, everybody's talking about Nancy Pelosi's visit to Taiwan, and they're literally not discussing anything that would relate to our issues, apart from perhaps a couple of news related to proposed relief to aging out children of certain immigrant workers in the United States. And also everybody is discussing why the Biden administration has not canceled Remain in Mexico protocol for people who are trying to come to the United States from outside to, for certain people, to request asylum. Why they haven't done so, even though the United States Supreme Court ruled in their favor, saying that they can live to remain in Mexico, we do not know. But this is the main issue, and it seems everybody forgot about essential workers. It sounds harsh and sad, but that's the truth for now. Hi, Kamal. Hi, Diana. Do you do work petitions here in New York City? Yes, absolutely. We handle petitions for the workers. Absolutely. Hi, Sumit. Hi, Sami. Hi, Loon. Hi, Beatrice. Hi, Mark. Hi, Van. Yeah, that's a great question. Is there any news about the 7 years amnesty? Not yet. I do not think we're going to hear anything for another month, if I would have to guess, okay? Because November is coming, and that's when the whole world is going to start, I think. Hi, Eric. I'm in, I like your Nick, from Miami. Hi, Anjum. Hi, Mohammed. Hi, Caesar. Hi, Mr. Chowdhury. You can easily see my number at the bottom of this video. It's 917-885-2261. You do need to make an appointment. And hi, Lisa. Can you please repeat that I-130 process one more time? I-130 process, are you referring to how it's going to work if you're in court? So I-130 is a petition for an alien relative. Well, it's called alien relative. Now we use a different term, non-citizen. It's a basis for a green card or an immigrant visa for somebody who is a relative of a US citizen or a green card holder, right? So certain people, when they're sponsoring you, you can adjust status in the United States if you meet the adjustment of status requirements, like being inspected and admitted or paroled, not having certain criminal convictions, being a person of generally good moral character. Even if you are in court, immigration court, or removal proceedings. For example, usual example would involve marriage to a US citizen while you are in removal proceedings. But usually, if you are in removal proceedings or in court, USCIS is going to have jurisdiction over your I-130 form that's going to be filed by your US citizen spouse. But immigration court is going to have jurisdiction over your adjustment of status or I-485 petition, unless and until your case will be dismissed in immigration court, usually. It's not the case for somebody who is called to be an arriving alien. The easiest way to find out if you're an arriving alien or not is to look at your notice to appear. At the top of the notice, there will be charges against you that's going to say something like that. You're not a citizen or national of the United States. You arrived at such and such time and near borders somewhere, blah, blah, blah. So that document is going to tell you if you're an arriving alien. Above those charges are boxes that says how DHS sees you, right? If you're an arriving alien, then you can file for adjustment of status in USCIS, even if you're in immigration court. If you're an arriving alien, interestingly enough, you can file for adjustment of status. Very important, guys. You can file for adjustment of status with USCIS, even if you have an order of removal against you already. It's like strange. Some things in the United States immigration law are truly fascinating, and this is one of them, okay? That you can still adjust your status with USCIS if you're an arriving alien, even if you are in immigration court. However, you need to keep in mind that you have to be adjustable and there shouldn't be other problems, right? Usually would be criminal, some sort of criminal convictions. Hi, Dolet. Thank you for informative videos. Can you please answer my question? My asylum application preliminary granted by asylum office in 2020, but pending review with supervisor for 2 years. I filed congressional inquiry with no result. How long from your experience it takes for supervisor to make a decision? I have to tell you that each case is different. I think what happened is that you got stuck in those forever lasting background checks, right? Because that's what it is. Thankfully, my clients had this situation, but it wasn't lasting more than like 60 days. So 2 years sounds a little bit excessive, right? I mean, you should work with an attorney to see if you would like to file a certain lawsuit, perhaps forcing USCIS to make a decision on your case at this point, because it does seem to be too long, right? Like, okay, maybe a year, it's okay, but 2 years is kind of too long. So see what's going to happen. And you stated that there was no result from the congressional inquiry. Was there no answer at all? Or was there an answer that they stated that you're undergoing background checks? So if it's background checks, I'm telling you, this is the toughest thing to deal with, because technically government is entitled to run the background checks, right? But too long, that's probably unreasonable for 2 years, right? So I think you should work with your lawyer to see if you want to push him further. Hi, Sadiq. In the asylum case, if you're pending more than a year, what does it mean? Nothing really. There are cases in asylum cases that are pending, guys, for 5 years with no interview. So I wouldn't say that it means anything at all, unfortunately. Perhaps just the fact that you got into the backlog. Because I tell all my clients and new clients as well, the problem is that, yes, there is new order under which cases that are being filed last should be called first. But not everyone is being subject to that order. We have cases that were filed this year and last year, but the person was not called for the asylum interview. And they also got into this backlog somehow. And when they will be called, I'm telling you right now, there is not a living soul that knows, apart from that computer that gives you appointments, shoots those appointments at you. Hi, Val. I have a question. A few days before you post an informative post, a U.S. citizen parent can help son, adult son, or daughter if they're legal all the time. Yes. So that's what's happening. When you have a parent who is a U.S. citizen, U.S. citizen parent can sponsor adult son or daughter regardless of their marriage status. If your parent is a green card holder, they can file for you only if you are not married, if you are an adult son or daughter. But if you are in the United States, to use this way of getting a green card, first of all, you will have to wait for a long time. Depending on the country you're from, it may be decades. Like, for example, for people from the Philippines. And second, you must show that all this time that you've been living in the United States, you maintained lawful non-immigrant status. If you cannot show that, you will not be able to get a green card in the end without leaving the United States. In many cases, people cannot show that. Their visas, for example, expired. Depending on what kind of visa they had and what happened to them afterwards, they may or may not need a waiver if they leave the United States to get their immigrant visas overseas. And usually people in this situation who are being sponsored by their parents and the people themselves, so adults, are going to use what's called I-601A waiver route. It means that first the parent has to file that I-130 petition. Then the petition must be current. Then the petition has to be transferred to the National Visa Center. Then you have to pay the National Visa filing fees for the immigrant visa and adjustment of status. After that, you're going to be filing for that I-601A waiver. When the waiver is approved, and if it's approved, you're going to continue with the national visa process by submitting necessary paperwork, waiting for your immigrant visa appointment overseas. And then when the appointment is given to you, you're going to leave the United States, get your visa overseas, and come back. Okay? A long way. But it's possible. Only it takes forever. Shortcut would be if you are placed in removal proceedings. But here you have to show that you've been in the United States for 10 years. This is something I spoke about at the beginning of this presentation, this 10-year green card or cancellation of removal for non-permanent residents. When you show that you've been in the United States for 10 years, you have a qualifying relative, which can be your parent, who's going to experience extreme, or it's actually called exceptional or unusual hardship. And if you prove that connection and that you're a person of good moral character, you may be ordered to have a green card in the United States without having to leave the United States. The only thing that currently, even if the judge makes this positive determination or wants to make this positive determination, you still have to wait for your green card for 2.5 years after you win your case. Why? Because there is a crazy backlog there too. Somebody who is going to resolve all those backlogs is going to be the most popular person, absolutely popular person among immigration lawyers, immigration clients, immigrants in the United States, and everybody who is affected, which, by the way, in the United States are millions of people, okay? Millions of people. Hi, GD. Can judge refuse to sign a joint motion already signed by the government attorney for prosecutorial discretion? Prosecutorial discretion be granted with pending on authority only when approved on authority. Can judge do that? I think they can, technically. Why? If they couldn't, why would you need the motion on signing off, right? Why would you need to file the motion? But have I ever seen it? I've never seen it. But I know sometimes it happens. Before. Not currently. I just remember reading something about that, and I was like, whoa, look at that. But it can. For that reason, even though you have a joint motion, I suggest when you file your request with the judge, you still have to be prepared. You have to, you stated that I-130 was filed. You still should attach some evidence of that real marriage so the judge has no doubts as to that the judge's action will be proper in the case. Okay, can they? I think they can. I don't think that anybody can tell a federal judge what to do apart from the attorney general if we're talking about immigration judges. And by the way, it's interesting in itself that there is an attorney general who tells judges what to do because there should be judicial independence. And there is a big movement in the United States for immigration judges to have that independence, just like federal judges. Nobody can tell federal judge what to do. Nobody. All right, guys. Thank you very much. I see one more last question. Hi, Equity Justice. Do you have to take the jab to file for registry? Because the USCIS website said no medical exam is required to apply. This is how it is. If no medical exam is required to apply, then you don't have to comply with the requirements for medical exam for those who filing for green card through adjustment of status. Interestingly enough, if you file for the green card, for the same green card, based on cancellation of removal, you also don't have to take the jab. Interesting, right? So, as I said, immigration law in the United States can be truly fascinating unless a special provision is made. And you see, after you made this comment, it can be made. Because some people will think, oh, that will be unfair. Those immigrants should be vaccinated. And we'll see what's going to happen. I truly hope that the registry is going to work, but they can insert that provision. Currently, there is none, to my understanding. And currently, I believe the proposal that is on the table says only that they're going to change the date. There is no more additions to the rule. And if that stays, then you will not have to show that you're vaccinated against COVID, right? Because every other immigrant who is filing for adjustment of status must show that, right? Unless you're going to file for a special waiver, which is extremely difficult to receive, but possible, but from what I understand, extremely difficult. My clients usually comply, okay? Because if you wait for 20, 30 years to get your green card, I mean, you know. Hi, Eric. If I tried to expedite my advance parole but got email based on review of your request, case does not meet one or more of the expedite criteria, otherwise merits expediting process. Gee, that's harsh. Means they denied your expedite request. I would say you still can try. That's fine. I understand. I think what happened was that you filed your advance parole request with USCIS, right? That's what happened? Yes. And truly you would have been better off, you would have been better off if you perhaps used different route and showed up, if you could, at USCIS local location. But I'm going to tell you, once you file with USCIS, they will not consider an expedite request in person. But it means that they denied your request. I mean, you can always refile if you disagree with them and have more evidence as to the reasons why your AP has to be expedited. Okay. Sometimes it just takes a lot of energy to get what you need, but it's possible. Well, thank you very much for watching, guys. It was a pleasure. Thank you for connecting today, asking your questions, commenting. I hope you find this video helpful. If so, then please like, share this show. Please subscribe to my channel if you haven't done so, or follow me on Facebook page. And we're going to meet again if everything is well. I hope everything will be well with me and with you in a week. And I'm going to provide you with new updates as soon as I have them. Thank you, guys, and have a great night.